Okay, here we go again. First part of the application. Sorry, the first part of our application. Okay, going to start again. This is verbatim from the case. So this part you can put in brackets. This part will be quoted from the case. Okay, the court held that construed in the light of its history and context. Okay, Section 23 of the Black Administration Act is an anachronistic. Anachronistic means it comes from the Dark Ages. It's so old it can be regarded as coming from the Dark Ages. Anachronistic piece of legislation which assified, okay, official customary law and caused violations of the rights of black persons. Okay, next. Okay, further, the court declared unconstitutional and struck down Section 23 of the Black Administration Act and its regulations, basing its decision on the fact that these were manifestly discriminatory and in breach of the right to equality in Section 9 and human dignity in Section 10 of the Constitution. The court further held that both the substantive and procedural provisions relating to customary law created a racially segregated system of administration of estates that was inconsistent with the provisions of the Constitution. Next, the court held that the African customary rule of male primogeniture in the form that it has come to be applied discriminates unfairly against women and children born out of wedlock and accordingly declared it unconstitutional and invalid. Okay, next. The court held that although the courts should ideally develop customary law and align it with the Constitution, it was not feasible in this matter. Okay, Sorry, students, I broke up there for a while. I will repeat this next part. Okay. Okay. The court held that although the courts should ideally develop customary law and align it with the Constitution, it was not feasible in this matter or in this case. The court further held that the provisions of the Intestate Succession Act and the Administration of Estates Act, with special modifications to accommodate for polygamous marriages, would apply to all estates previously regulated under the Black Administration Act and the rules of male primogeniture until the legislator was able to provide a lasting solution. Okay, what I will do is I will take screenshots of what I'm reading to you, and I will, at our next revision session, post it on the chat. Okay, but remember, this is also recorded, so you can go back to the recordings as well. Okay, the court order of the court was made retrospective, dating back to the 27th of April 1994, with completed transfers of ownership insulated, except in cases where the heir had notice of a challenge of the legal validity of the relevant statutory provisions and the rule of male primogeniture. Okay? With regard to the administrates, the court ordered that from the date of judgment, future deceased estates which would have previously been administered by magistrates in terms of the Black Administration Act must be administered by the Master of the High Court in terms of the Administration of Estates Act of 1965. Okay. Any questions related to application? Any questions related to application, students? Any questions related to application? Any questions related to application? Any questions related to the application process? Okay. If there's no questions related to that, Nadia, why was it not feasible in that case? Very, very good question, Nadia. Very, very good question. Okay. It was not feasible in this matter because why? These provisions of male primogeniture, okay, discriminated. Why? Because there was unfair discrimination against women and children born out of wedlock. Okay, that's why it wasn't feasible to develop the those provisions of African customary law. Hence, the court declared it unconstitutional. Does that make sense, Nadia? Does that make sense, Nadia? Okay. Now we go over to the C in FIRAC. Okay, what does the C in FIRAC stand for, students? What does the C in FIRAC stand for? Okay, Paris, Nadia, Denzel, and Tokozo is telling me it's the conclusion. Okay, you correct. Now, what is a very important aspect about the conclusion? Thank you, Balisa. What is a very important aspect about the conclusion, students? What is a very important aspect about the conclusion? Nadia, very good. Not to introduce any new information in your conclusion. Not to introduce any new information to your conclusion. Okay, not to introduce any new information to your conclusion. Okay, here's one question from Queen, I think. Okay, Queen, welcome. Okay, let's go to the conclusion. I'm going to read my conclusion to you now. I'm going to read my conclusion. Okay. The Constitutional Court declared unconstitutional and invalid the African customary rule of male primogeniture, which allows an oldest male descendant or relative to succeed to the estate of a black person. Okay. It was also declared unconstitutional and invalid Section 23(7) of the Black Administration Act, which unfairly discriminates against women and others with regard to the administration and distribution of black deceased estates. The court proceeded to impose as an interim measure the provisions of the Intestate Succession Act on estates previously dealt with under the Black Administration Act. It also made special provision for estates relating to polygamous marriages and that estates previously administered in terms of the Black Administration Act must now be administered by the Master of the High Court in terms of the Administration of Estates Act. Okay. Must I repeat that, students? Do you want me to repeat that for you? Do you want me to repeat that for you? Or do you have any comments or questions related to that? Do you have any comments or questions related to that? Do you have any comments or questions related to that? Okay. Palisa, I will repeat it one more time. Okay. The Constitutional Court declared unconstitutional and invalid the African customary rule of male primogeniture, which allows only an oldest male descendant or a relative to succeed to the estate of a black person. Okay, that's the first part of the conclusion. Secondly, it also declared unconstitutional and invalid. Okay, also declared unconstitutional and invalid Section 23(7) of the Black Administration Act, which unfairly discriminates against women and others with regard to the administration and distribution of black deceased estates. Okay, that's the second part of the conclusion. That's the second part of the conclusion.
Thank you.
That's the second part of the conclusion. Let's look at the third part. It further goes on to tell us the court proceeded to impose as an interim measure the provisions of the Interstate Succession Act only on estates previously dealt with under the Black Administration Act. Okay. It also made special provisions for estates relating to polygamous marriages and the estates of previously administered in terms of the Black Administration Act must now be administered by the Master of the High Court in terms of the Administration of Estates Act. Okay, that is the case summary in terms of the FIREC method for the bear case. Any other questions for me? Any other questions? Any other questions? Okay. If there's no questions, that is your case summary for B. Okay. I will post next week. I will post some more case summaries for you. Okay. Now I want us to go. I'll tell you what page in the course outline we must go to now. Give me a second, let me just access the course outline. Adam, it will be mostly MCQ. I can't guarantee that it will be only MCQ. Okay? A part of the exam is MCQ. I'm not going to guarantee that it's only MCQ, but you have to prepare for MCQ questions. Okay? Paris, are you saying it's only MCQs? Okay. Okay, guys, please be mindful that even though it's MCQs, it's going to be challenging. Okay. Okay, so I want us to go to our course reader and we can go. I finished last on page 49. Okay, so we can go to page 49 and start from there. Okay, so on page 49, um, the last time we spoke, I spoke about the three types of judgments that are handed down. Okay, we spoke of majority judgments, minority judgments, and separate judgments. I told you it's only the majority judgment which creates judicial precedents, which can be used in future cases, and that only majority judgments are regarded as binding and authoritative. Okay? Majority judgments will now form part of our sources of law, which fall under case law or judicial precedent. Okay, it's regarded as a primary source of law. Okay, I told you minority judgments and separate judgments, although not binding, okay, they do not establish precedent, but both types of judgments, minority as well as separate judgments, they are sources of persuasive value. They are regarded as sources of persuasive value, and they now become a secondary source of law. Okay, any questions related to that? Any questions related to that? Any questions related to that? Okay. So if there's no questions, we will continue. Okay. If there's no questions, we continue. Okay. Students, very, very important. Okay, page 52. Hmm? Paragraph 30.5, our Latin terms. So it's from page 52 up until the top of page 59. Okay, please be mindful that you must know all of that. Study it, know it verbatim. You are going to get quite a few marks for Latin terms. Okay, those you should regard as bonus marks. Okay, those you should regard as bonus marks. Um, Let me just see what we have to go through in terms of communication and litigation skills. I want us to start on page 64, paragraph 4.5, logic and legal arguments. Logic and legal arguments. Okay. Okay. I'm on page 65 and it tells us at paragraph 4.5.1 what logic is. Okay. So logic has to do with the ability to solve problems by means of argument. Okay. And this is essentially what lawyers do. We argue, and the basis of our argument is the law. Okay. So logic, but how must we present this argument? How must this argument be formulated? This argument must be formulated and argued in a logic manner. And logic, as I said, has to do with the ability to solve problems by means of argument. Okay. I see there's a few more students who joined. Ayanda Mukizia has joined. Mrs. Mabela has joined. Okay. Is it the first time you guys are joining? Okay, welcome, Mrs. Mabela. Okay. So logic has to do with the ability to solve problems by means of argument. Okay. Further on, it tells us it tries to provide answers on what is involved when a point is argued. Okay. So we go to paragraph 3. Okay. And it tells us the following, that logic can thus be said to be the study of rational thinking, and it is concerned with the structure of valid arguments. Okay? Can to repeat that? Logic can thus be said to be the study of rational thinking, and it is concerned with the structure of valid arguments. Okay? Now, let's ask the question, what is an argument? Okay? And it tells us here in the third paragraph, please underline that, please highlight it. It tells you in the third paragraph that argument, it is a network of statements in which one statement is made on the strength of the rest. Argument is a network of statements in which one statement is made on the strength of the rest. For example, the garden is wet because it rains. Okay? Tells us that this is a simple argument with the ground of the argument or the reason for the argument called a premise. Okay? So it rains, that is a premise, and the conclusion is that the garden is wet. Thus, the premise leads to a conclusion. Okay? So now we're going to look at a few ways of reason and argument. Okay? The first form of reasoning is deductive reasoning. Let's look at deductive reasoning. Okay? And the basis for deductive reasoning students, the basis for deductive reasoning is that the conclusion follows directly and fully from the premise. The conclusion follows directly and fully from the premise. Okay? So let's take the example. I'm on page 65 under the heading deductive reasoning. And it tells us all humans are mortal. Okay? Socrates is human. Socrates is mortal. Okay? So the premise here forces basically a conclusion on us. We're going to see now when we do it in terms of a legal example. So in terms of deductive reasoning, it tells us that the premise forces a conclusion on us. Okay? If we think about the conclusion, it is clear that it does not contain new knowledge. It might contain new insight, But to know what the premise claims is to know the contents of the conclusion. Okay? Meaning, the conclusion shows what the premise in the combination contains. Okay? So, let's go to page 66 and let's look at the example of a rape case. Okay? Okay? Look at the example. Abel is charged with the rape of Barbara. Okay? He denies the charge, stating he never had sexual intercourse with her. Okay? The prosecutor calls an expert medical witness who testified that he found traces of semen in Barbara's vagina, which is sample A. Okay? And that a DNA analysis of this semen sample exactly matched DNA of a semen sample obtained from Abel B. The expert evidence further establishes that it is impossible for two strangers to have identical DNA characteristics. Now, let's look at deductive reasoning. Okay? And in terms of deductive reasoning, the court may conclude as follows. Premise 1. Okay, let's look at premise 1. Semen sample A was taken from Barbara's vagina, which is true. Premise 2. Semen sample B was taken from Abel, true. Premise 3. The DNA of sample A was an exact match of the DNA of sample B, true. Premise 4. It is not possible for two different people to have identical DNA, true. Premise 5. Both semen sample A and semen sample B came from Abel. Let's look at the conclusion. The conclusion, therefore, is Abel had sexual intercourse with Barbara. Okay? Any questions related to that, students? Any questions related to deductive reasoning? Any questions related to deductive reasoning? Okay. Okay. Let's go to inductive reasoning. Okay. The second form of argument which we regard as an opposite of deductive reasoning, is inductive reasoning. Okay. Here, the form is the same as for deduction, but the conclusion contains something new, something more that goes beyond the premise. Okay, so let's go to the example on page 67, which relates to a bail hearing. Okay, let's go to the example on page 67, which relates to a bail hearing. Students, give me 1 second. Okay, page 67. Okay, let's assume Abel was arrested on suspicion of raping Barbara and now applies to court for bail. Okay, so the test the court will use to decide whether to release Abel on bail or not is the interest of society. The presiding officer will consider the following factors. Okay. Will Abel return to court to stand his trial if released on bail? Will Abel interfere with state witnesses? Will Abel be a danger to society if he is released? Okay. Then will Abel's own life be in danger? Okay. Meaning, to decide whether Abel should be released on bail, the court will look at evidence supporting the above factors. After hearing evidence and argument, the court will answer the following questions. Okay. If Abel is released on bail, is it probable that he will stand trial? If Abel is released on bail, is it probable he will interfere with state witnesses? If Abel is released on bail, is it probable that society will be in danger? And then lastly, if Abel is released on bail, is it probable that his own life will be in danger? Okay. Now, here is something new. Remember, um, inductive reasoning speaks of um, but the conclusion contains something new, something more that goes beyond the premise. So here's how something new that goes beyond the premise. So if, for example, evidence is led that a mob of 30 men is waiting outside the courtroom, threatening to kill Abel as soon as he is released on bail, the court may reason as follows. Okay. Premise 1. A group of 30 men is outside the courtroom too. Premise 2. Many members of this group are uttering threats to kill Abel too. Conclusion. It is therefore probable that Abel's life will be in danger if he is released on bail. Okay? So it tells us here the court does not know for sure what will happen, but there is a probability that Abel could be killed and therefore should not be released on bail. Okay, so those are your two types of reasoning. Um, Students, are there any questions for me? Adele, your hand is raised. Okay, students, any questions for me? Any questions? Um any questions? Any other comments? Any questions or any other comments? Okay. So we when we continue, we are going to continue with activity 4.6. We're going to do the divorce case. But what I want you to do in the meanwhile is to read the question, and then we will start on page 70 with the with the process of a civil trial. Okay, we'll start with the process of a civil trial. So, what I'm going to do is I'm going to stop here now. On Tuesday, we will continue from activity 4.6. We will continue from there, and then I will be online at 5 p.m. again for a revision session on ILW. Students, are there any questions or comments for me before I log off now? Any questions or comments before I log off now? Those of you who have joined recently, just put your student numbers into the chat function for me. Okay, just put your student numbers into the chat function, and then um, Denzel, just put your student number into the chat function. That will um, serve as attendance. And then students, I will be online at 5 p.m. again for a revision session on ILW. Okay. Um, so those of you who do ILW, I will be online at 5 p.m. again. Thank you, students. Good afternoon.